have someone from Department of Revenue involved, and because this is going to have a material impact on what they do, and so that perspective would be really valuable. So she reached out to her team, and we were fortunate enough to have Willie and Victoria volunteer, or maybe get voluntold, whichever way. We're happy you're here, to work with us on this project. And so to the extent that they see issues, I know it's been really wonderful to have Secretary of State's office involved in this process, and has added a lot of value to our discussions. So so I'm looking forward to their involvement. Sandy, were you able to forward them a copy of the draft document that we're working on off of?
I'm doing it right now.
Okay. Yeah. So Victoria and Willie, I don't know if you want to say a little bit about yourselves and what your background is, but welcome. And I really appreciate your willingness to work with us. This group is a little bit smaller too, just so you know, than it usually is, because August and a lot of people are off this time of year, although I think given COVID, many fewer are taking vacation right now than ordinarily would be. So anyhow, so I don't know, Willie, Victoria, do you want to say anything about yourselves or your backgrounds? And after that, then we can get into the regular part of the agenda. Yes, no.
This is Victoria. Thank you, Valerie. Hello, everyone. My name is Victoria Johnson. I am manager of Corporation Policy Appeals and Nexus, the Department of Revenue. I have been with the department just a very short period of time, 3 months now. I came from the private sector, spent 20 years in the energy industry, and prior to that, 10 years in local government. And I'm an enrolled agent, and am enjoying my work with the department. I find it very fascinating, and I volunteered for this for this work. I just want to let everyone know I volunteer, and I'm happy to be here. All right, thank you.
We appreciate non-conscripted members. I know Deanna can be very persuasive, though. Willie, did you want to say anything? And then I thought maybe it occurs to me, Sandy, we should go around and introduce ourselves so they know who we are as well. So Willie, do you want to introduce yourself, and then we'll go around the screen.
Thank you, Valerie. So my name is Willie Lamb. I've been with the Department of Revenue for 10 years now. Most of my time has been with personal income tax. I started out as an auditor, became a lead worker, mentor, reviewer, and now I manage the Gresham District Office. Pretty much that time has really been around compliance. So I mentioned personal income tax. I've worked in, we've worked in closely held entities. So we have worked in corporations, partnerships, but I would say a lot of that's closely held. And that's pretty much it about me. And I would say thank you for inviting me to the group. And I was given this opportunity to join, and I'm excited to be here.
Thank you all. Oh, I'm sorry, Valerie.
Go ahead. No, Sandy, why don't you introduce yourself first?
Yeah, I'll introduce myself, and then Valerie, one thing is sometimes people see see different people on the screen, so I might just call on people to introduce themselves. It might be easier.
Sure.
I'll start first. My name is Sandy Weintraub. I am the director of the Oregon Law Commission. My job is to help to coordinate, make sure the meetings take place, keep records, and keep the whole process moving. I'm also the contact if you need any information, documents, have questions about the commission or any of the projects, or this project specifically. Just feel free to contact me directly, and welcome. We'll start with Cody.
Okay, yeah. Hi, I'm Cody, and I'm a commercial litigator and appellate attorney at Larkins Vicura Kaiser.
Great, thank you. Michael?
Morning, Michael Walker, Samuels Yulin Cantor, partner there. Practice includes business transactional work and estate planning.
Great. Aurelia?
Hi, I'm Aurelia Erickson. I work at McGahee Erickson doing civil litigation and a lot of business breakups and disputes between members of closely held companies.
Thank you. David?
Hi, I'm Dave Ludwig. I'm partner at Harley Water Witt. My practice emphasizes business transaction and financial services predominantly.
Great. Talitha?
Hi, I'm Talitha Randall. I'm an extern with Commission. I'm really enjoying my time here. Thank you for letting me be here.
Thank you. Valerie, I think you don't need introduction.
What if I want to introduce
You are
myself?
welcome. You are welcome to introduce yourself.
So I'm Valerie. So I'm vice chair. I don't know if I actually have a title in this thing, but so I'm nominally in charge of herding the cats. It's really Sandy's job. And I'm a partner at Samuels Yolen Cantor, and my practice focuses primarily in business transactions and tax controversy. So, you know, when all of y'all send those lovely love letters to the private sector, that's sweet. We help people with that. So, and so I'm super excited to be here because this is a really wonderful dynamic group, and we've had some really great discussions so far. So I hope that you enjoyed as much as I have.
Lane, I see you're joining us today. Welcome.
Yeah, good morning. Lane Shetterly, attorney in Dallas. I was formerly chair of the Oregon Law Commission. Now I'm just a has-been on that august body, but I'm still a member of the Uniform Law Commission from Oregon. And so as a member of the Uniform Law Commission, since this work group is looking at the Uniform LLC Act, I've been monitoring it from a distance. I've attended a couple of meetings in the past, but it's been a while. So I just wanted to check in today just to follow along and see how things are going.
Great. Next, Susan Gravy.
Let me unmute myself. Hi, Susan Gravy with the Oregon State Bar, and I am the Public Affairs Director, which means I deal with legislation and public policy for the bar, and I'm happy to be here and continue to maintain some, at least, fingers in the pie to figure out what the issues are that you guys are dealing with, because it will definitely end up in the legislative process. So thank you.
Great. James?
Good morning, James Hine. I'm a M&A and general business lawyer at Tonkin.
Next is Kyle.
Hi, good morning. Kyle Mueller. I am a commercial litigator at Stolburn. I do a variety of different types of cases, but where my work intersects with LLCs is primarily in business disputes, business breakups, some securities matters that involve LLCs.
Okay. Jamie?
Hi, my name is Jamie Weddle-Jones, and I am with the Oregon Secretary of State Corporation Division. I've been with the division for about 10 years, and I'm a compliance officer. And I'm really happy to be able to be a part of this group so that I can share the Corporation Division view on the laws for LLCs.
Next, Cliff.
So I'm a partner in the Business and Transactions Group at Davis Wright Tremaine, focusing on emerging growth companies and startups and doing everything from formation to financings to sales.
Okay, thanks. Teresa?
Hi, I'm Teresa Pearson. I'm a partner at Miller Nash, and I'm on the back end of everything, insolvency, reorganization, and when everything hits the fan. So we see LLCs in our world too.
And then not on video, but I think Kathy is here.
Yes, hi, my name is Kathy Yao. I'm a business transaction attorney, and I do federal tax and state and local tax law. And I work in Eugene at Watkinson Laird Rubenstein.
Great. And last, Mindy.
Good morning. I'm Mindy Whitcop, and I'm the supervising attorney and director of the Business Law Clinic at the University of Oregon. And we work with a lot of small businesses, and I train law students to form a lot of limited liability companies, primarily very small limited liability companies of 1 to 2 members, maybe 3 or 4, but very small businesses with very low budgets. We provide free legal services.
Great. Thank you. So that's everyone we have today. There are some other members of the group who weren't able to attend, but this is a pretty good representation of the types of folks we have working on the project, and look forward to working with our new members for the rest of the way. Really quick, Valerie, you wanted me to touch on 105 before we get started?
Yeah, I'll preface that by saying how glad I am that we made the decision early on to not try for the 2021 legislative session, because it looks like it's going to be even uglier than we thought it was going to be. So anyhow, with that, I'll turn it over to Sandy.
Yeah, just at the end of last meeting, we had discussed that we really wanted to get some feedback, both from the business community specifically, and also folks in the legislature about some of the key issues that we've discussed the last several meetings on 105. I've reached out a bit. I need to cycle back, especially with folks in the bar, from Susan and some others. But we really do want to get a group of folks together to really review the decisions that the group made, to decide whether it's palatable. So Valerie and I spoke, and we really think it's a good idea to actually move forward with some sections to get them under our belt. We have Cody who's prepared on 410. We have Teresa who's prepared on 5. So we will cycle back to 105, just put a TBA on it at this point. If any of you know people who are well connected, I guess, politically in the business world, I don't really know, other than I know Susan with the bar likely does, but who you think might give a solid perspective on the types of decisions we were making on 105, please forward those names to me, and I'm happy to run it by them.
Yeah, I mean, part of the discussion that Sandy and I had is that given the COVID budget situation, it's hard to get people's attention right now.
Yeah.
So we're going to wait until things settle down a little bit, but we want to start putting out feelers before we get that group together, sort of a secondary discussion group. So Susan, we'll probably need to circle back with you as well.
Yeah, definitely.
And I think Cliff, you had some suggestions as well. So we'll be reaching out probably over the next month and a half or so.
Yeah.
But we want to be deliberate about this and make sure we get the right people, but also that they have the, brain space to deal with it. And they're not trying to deal with the world on fire at the same time. So.
And Valerie said, the good news is it's not urgent. We're not trying to push anything through too quickly. And we really do want to get a perspective to make sure that whatever we do bring is going to be palatable and possible to pass. So,
exactly.
So with that, I think I just resent, Cody had prepared a document for 105, but also for 410 to lead our discussion. I just resent that in the last 10 minutes or so. So please review that, and Valerie, unless you had anything else, I'll give the floor to Cody to lead our discussion.
Well, so I just want to make sure, Willie and Victoria, you have a copy of the act, right, that we're working off of?
Yes.
Okay.
I do.
Yes.
Okay, perfect. All right, Cody, take it away. Thank you again for agreeing to handle this section.
Sure, no problem. So 410 is one of those provisions of ROLCA that has been essentially significantly modified by multiple states, including Washington and California. I think Idaho adopted 410 whole scale. But the key difference between 410 and current Oregon law, as well as what Washington and California have done, is that our states treat essentially, in large part, member-managed and manager-managed companies similarly in terms of right of access to information of members, whereas ROLCA says that if you're in a manager-managed LLC, you have a substantially reduced right to access to company records. For example, if you look at ORS 63771, subsection 1, it lists a whole series of types of documents that every LLC has to keep and then has to share with members, regardless of the management structure of the LLC. And Washington does the same thing. ROLCA doesn't have any such list of mandatory records that need to be shared with the member, regardless of management type. It strikes me as a significant policy decision. And I know we've talked a lot about how the legislature is concerned about transparency. And in large part, I think that's related to third parties. But I also think that the same transparency concern prevails here within the membership of the LLC. And so for those reasons, and I also think it's just a better policy to have that transparency, I propose that we follow the RCW, the Washington law, more closely on this, which is more similar to our own law. Washington did adopt some aspects of ROLCA. They basically say there's a minimum right to information, and then if you want more than that, you have to go through the ROLCA process where you have to make a demand for books and records, and then the company responds. And those familiar with litigation over books and records demands in Delaware know that there's tons of cases about it. It's often highly litigated in very high stakes mergers, or whenever some bad news comes out about a major corporation, there's often a lawsuit, and there's books and records disputes in advance of that. In part, we don't really have that level of litigation in Oregon so much, just nowhere near as common. And at any rate, so those are the basic reasons why I think we should focus on the Washington model, which is similar to our current model, rather than going for the full ROLCA. In a manager-managed LLC, members don't really get information. So I'll start out with ROLCA, or I mean RCW. This is RCW 2515-136, which is their relevant statute. And subsection 1 of that lists a whole bunch of documents that an LLC has to keep at its principal office. That is essentially the exact same thing as ORS 63771, and the Washington statute lists all of the same records that are required by Oregon law, as well as some additional records. The key difference is that Oregon law currently requires the LLC to keep a current list of the full name and the address of each member and manager, both past and present. Washington law doesn't require that as part of this automatic right of information that members have. Washington law puts that list of members and managers under its, hey member, if you want that list, you have to jump additional hurdles. Whereas Oregon, there's no additional hurdles to get that information. And to me, I would think that that information is something that you shouldn't have to jump through additional hurdles for. The whole idea is, know your partner with the LLCs. And that's why, third-party creditors aren't allowed to come in and take over a membership interest and so forth. And to me, it's inconsistent with this idea of know your partner, and we're partners, and we shouldn't, have third-party partners forced upon us if you're not allowed to know who your fellow partners are. That part doesn't make any sense to me.
So Cody, I'll stop you there. Cliff, do you have any thoughts about that?
Yeah, sorry, Valerie, I'm actually kind of focusing on something else right now. I kind of missed that last point.
Okay.
Oh, well, I guess maybe the first part could just be, do people agree in general that there should be this list of types of records that every LLC has to keep and then ultimately share with a member upon request? Because that's not at all in ROLCA, but that is in current Oregon law and Washington and California.
Yeah, and I think, to the extent that we've been evaluating, areas where ROLCA has diverged from current Oregon statutes, and there's a clear preference in the statutes for transparency. I think we've been choosing to go in that direction because it reflects obviously some fairly recent policy decisions on the part of the legislature. And it would seem to me, and I agree with Cody, that this is a area where that applies, where that could apply. So I agree with you, Cody, in that I think that it makes sense to go in that direction. I think it's useful to have a list of documents that are required to be kept at, the office of the business or some other designated location. My thought though, and why I wanted Cliff's thought on this, is that, the model where you have a heightened hoops you have to jump through to get that information on, who the partners are and who particularly former members are or former partners are, that seems to be a area that, is probably a litigation thing, probably derives from some concept of Delaware, the Delaware privacy laws. So, so Cliff, I'm curious about what you have to say about that, because I know you've had some strong opinions about in this area in the past.
Honestly though, with respect to disclosing the names and addresses of members, it's never been a big issue for me. I think it's kind of a minimal piece of information to be able to provide parties. And actually, I generally advise our clients to provide more transparency on this point.
Okay.
So I guess I don't have any strong opinions either way on this one.
So I'll jump in. I agree with the principles that you laid out, Valerie. And I think on the list of members where Cody was most recently talking, it's worth noting that Chapter 60 for corporations does require the shareholders list be made available for inspection. So it would be a divergence if we went away.
A divergence from the corporate standard. What about the idea, though, of having to keep a list of past members?
Well, I favor requiring the companies to keep this information and to have it because I think it's consistent with the need for transparency. And sometimes you do need to go back and sort out who got what and how, and knowing who past members were could be very helpful for that.
You have a very specific perspective on that, Teresa.
I won't deny it.
I do worry about companies needing to maintain records into perpetuity, though. I mean,
is there
years?
Yeah, I know. I agree. I was thinking about that too. Is there some, I was thinking on the one hand, you don't necessarily need a list of who were your members 30 years ago. On the other hand, I imagine it's almost never when somebody would actually be asking for, tell me who your members were 30 years ago. But I'm curious for the practitioner, the transactional attorneys, is this an issue that companies are having a hard time with or complaining about, or I mean, is it difficult? And if so, maybe we can address that.
Michael?
Cody, I don't think it's a problematic area, frankly. I guess I've number one, I agree with the point about transparency. I think, as we've said before, we give some deference to ROCA, but if we have a clear policy that, particularly a policy difference that's present in ORS 63, then I think that sort of that deference switches. From a practitioner standpoint, I guess I've always liked having more specificity in the statute about here is the list of records that you must maintain. And you look at ROLCA and you really don't see that. It's fairly vague. I think it's vague by design. And I guess maybe it's just what I'm used to after working under 63. So this is an area where I would probably not have a problem departing from ROLCA. I guess I'm most interested, Cody, as we go forward, where your proposals ultimately on a net basis differ from current ORS in this area. So you don't have to answer that right now, but I'm sure you'll touch on that as we go through the section.
Yeah.
And the other point on that is just keeping in mind that you're going to have the member information, and it'll be included on their tax returns, because everybody will be receiving K-1s.
Mm-hmm.
So the issue rarely ever comes up for me as well, but I'm sort of in Michael's camp. Also, I get a sense of the members maintaining some, I use the word corporate, but corporate compliance. They actually have an entity and they need to maintain records for it, and they have an idea of what kind of records they need to maintain. So I think that would be helpful.
Yeah, I agree. All right.
So I'm understanding that there's agreement on this principle of having a list of required records, and it sounds like everyone agrees that this list of members should be one of the required records. And other than that, so my proposal had been to adopt section 1 of RCW 2515-136 as it is right now, and then add, it lists 1A through I, and I was going to add J, which was this member list, and I was just going to copy and paste the language from current RS 63771-1A. And so I guess I'm happy to discuss in more detail the list of in the RCW.
I think we're good with that.
Is there anybody who thinks we shouldn't do what I just proposed? Okay, so I think that we're solid on that. And then I'll move to subsection 2 of the RCW. This is talking about how you can get those records that we just were talking about. This is sort of the automatic right to get the records. You have to make a 10-day demand, and you can ask during regular business hours. That's all pretty similar to current Oregon law, which is in 63771 sub 2, which requires a request and at ordinary business hours and so forth. That's similar to RCW subsection 2. The RCW has an additional sentence at the end of that, which refers to this membership list and basically talks about how there can be some redaction of the membership list. I'm not sure why that, I didn't understand why you would have a membership list that would be redacted, but in any event, because we're requiring the membership list to be kept and given without any special reason for the request a member might have for that list, I think we should strike that sentence from RCW subsection 2. And so I would suggest that we just have our section say, on 10 days demand made in a record received by the LLC, a member may inspect and copy during regular business hours at the LLC's principal office the records required by subsection 1 to be kept by a limited liability company. The member need not have any particular purpose for seeking the records. The end. And I would have that be our section 2A of our statute. And I'm curious what people think about that.
Do we have any idea why Washington made that provision for redaction? I mean, what sort of confidentiality were they concerned about?
I don't know. When I think about it, I think maybe it's the addresses, because how can the names be confidential? That was the only thing I can think about, because the RCW talks about if the records contain information specified in subsection 3A of the Washington Code, which is the current and past list with full name and mailing address of every member and manager. Then the LLC may substitute copies of the records that are redacted to protect the information specified in 3A. So, I mean, I don't understand at all how that makes sense. Maybe maybe they're referring to some other type of document that contains the information about the members' names and addresses, and then you can redact that from the document that's not the list of members. Maybe that's what they're talking about, but since for us, you get the list of members as of right, then if some other document mentions who the members are, there wouldn't be a point to redact that. I guess now that I say it, I think that's why the Washington was doing that, because you don't get a member list as of right in Washington. And then I think they're essentially saying if you want some other record and it happens to have a member list in it, they can redact the member list.
So do we provide that under current law that members can get addresses? Because I mean, just thinking about recent incident with the judge and her son being murdered, you might have public officials who are members of LLCs, and they might very well have a good reason for not wanting to
Roberta, it's not necessarily public information. So this is information that members can get.
Yeah. This is not public information. This is just for other members.
No, but it could be a situation where you have a family-owned business and there's a divorce and it's a particularly nasty divorce, and for whatever reason, you know, there's a safety concern that one of the members shouldn't really know where the other one lives.
Right, but you know, it says last known business, residence, or mailing address of each member and manager. Right, so you could put a PO box for your address there if you had a safety concern.
Yeah.
I mean, I'm not worried about this particular provision. Yes, Susan.
I was just going to say, I think it was the 19th session when previous legislation went through, and I cannot remember the bill number, but they wanted to make sure folks were identified and this information was available. And I understand the need for if there's a safety concern, and maybe that can be addressed in a different fashion. But I do think having the information available was an important piece of the conversation earlier. For what it's worth.
Yeah, Jamie, do you, because a lot of the times you'll have an LLC and you have to leave members and their addresses. Jamie, has Secretary of State's office ever addressed a situation where there's a, you know, safety concern and so they want to do some redaction on the record?
If someone has a safety concern, then they can file for a personal exception as far as having their address listed, but we still require a disclosable address no matter what. So they have to give us something that can be disclosed. They can use a different address than their home address, and that's fine. They can file it with their business address and not have their home address, and that's fine. But we do require the address, and as far as our records are concerned, it's all public record.
Right.
And the only time that we wouldn't show it is if they did get the personal exception. In that case, there's a whole process they have to go through. The easiest way is they have to give us a disclosable address anyway. So we just make sure that they know that whatever address they're giving us is the one that they can have for public view.
Yeah, that makes sense. I mean, I think this is a manageable issue, Roberta, but you know, and I appreciate the legislature's concern. So I think the middle line that we walk here is, you know, we don't want to have 1,000 people saying they're living in a trailer out in Vernonia, right? But you know, you still want to make sure that you have some privacy options. Okay, Cody.
Okay, so this is moving on to, so I guess I'm understanding everyone's cool with adopting RCW sub 2 without the last sentence.
Yeah, because we made that decision on the first part.
Right. So so the next thing is a change I propose. So Washington did not adopt certain ROLCA provisions regarding how you might get information beyond that mandatory transparency list. So for example, ROLCA 410A2 says that in a member-managed LLC, the company shall furnish to each member without demand any information concerning the company's activities, affairs, financial condition, and other circumstances which the company knows and is material to the proper exercise of the member's rights and duties under the operating agreement or this act, except to the extent the company can establish that it reasonably believes the member already knows the information. And apart from that, on demand, any other information concerning the company's activities, affairs, financial condition, and other circumstances, except to the extent the demand for the information demanded is unreasonable or otherwise improper under the circumstances. I don't know exactly how much information falls into this category that isn't already part of the list of mandatory information we just talked about. And maybe the determination is that mandatory list is the list that we are saying is material to the proper exercise of a member's rights and duties. But to the degree that additional information or records would be material to the proper exercise of a member's rights and duties under the operating agreement or the act, it strikes me that the ROLCA provision here in 410A2 provides a useful additional tool for members to have access to information that's not on the mandatory list. And it also includes safeguard there. For example, that, you know, if someone's asking for unreasonable information, that wouldn't have to be shared. So I wanted to, I was thinking that was useful, that ROLCA provision of A2, and thought I would see whether people agree, and if so, we could add that to our statute.
I like that.
So I'm generally okay with A2A. I can see people getting really annoying with A2B though.
I'm fine with excising that also, because we already, under the RCW and ROLCA, it also talks about if you want certain information, you have to, you know, show that you have a purpose reasonably related to your interests as a member, and you describe with particularity what you want, and it's connected to your purpose. So in some ways, A2B is sort of redundant a little bit of that other provision. So I'm fine with getting rid of A2B.
Yeah, I like it with the guardrails better.
What does it mean without demand? What does that mean? Does that mean they just sort of, they have to issue an annual report sort of thing, or what?
Yeah, if there's information that the company knows and you as a member don't know, but it's material to the proper exercise of your rights and duties, they just have to give it to you so that you can do your job as a member. And so that you have the information you need as a member and that you're entitled to.
I mean, you would think that there would be some sort of fiduciary breach for failure to provide that, but you know, even without this provision, right? But I think that what this does is it makes it an affirmative responsibility of the company to provide that, you know, and think about, okay, am I in the packet to the members on, you know, member actions, am I giving them everything that needs to go to them?
So Cody, just a logistical question here. In ROLCA, this section is specific to member managed, but in your revised statute, you're adding this just globally into each kind of governance structure. Is that correct?
Yes.
Okay.
Yeah, I think that, I mean, it may be that as a member in a manager-managed LLC, you know, when you're thinking about what is material to the proper exercise of your rights and duties, you may not have very many duties as a member in a manager-managed LLC. But to the degree that you do have duties still, and you always are going to have some level of duties, then the company should be giving you whatever you need that's material to your exercise of your duties.
Okay.
Yeah, I'm okay with that. Anybody else have anything further on that? All right, let's move on.
Okay, so the next thing, and there's a typo in my notes here, but I was thinking that we should, A3, I was thinking that we should adopt the language from ROLCA 410A3, which says the duty to furnish information under paragraph 2, which as we just adopted was only 2A, also applies to each member to the extent the member knows of any of the information described in paragraph 2. This is to say that that information that's material to the proper exercise of the member's rights and duties, not only does the company have to give the member that information, but other members do too, if they know that information. And that makes sense to me as well. So I was suggesting that we adopt ROLCA A3.
I think there is a problematic issue with that, in that ROLCA sub 3 is under the umbrella of member managed LLCs. And so with our revision approach, where if we have a manager managed LLC, I guess I'm reluctant, particularly with an LLC that has a large number of members, I'm reluctant to impose a duty on those members in a manager managed context. I don't know if, what other folks feel about that.
Is it, I mean, I don't know that adds much beyond a typical duty of good faith and fair dealing, though. I mean, except it puts it in the statute rather than making it common law.
Well, it's a duty to furnish information.
Right, but if you have information that is relevant to a decision before an entity to which you owe a fiduciary duty, isn't that implicated by the duty?
Well, I think in a manager managed LLC, the duties of the members are fairly limited.
Right, but that's part of the whole I mean, yes, under current Oregon law, I think that's correct. But I think, where we're going with this is less of a distinction between the manager managed versus the member managed, and more who has the responsibility and authority to act on behalf of the entity. Right. So I think that's sort of the
managed LLC, typically members don't have authority to do so.
Right, but that's what I'm saying is that the concepts of manager managed and member managed entities I think are different under ROLCA. Yes. And so there's less distinction there, and so what it's doing is it's bringing those duties more into parity than they are in the current act, and it's a policy decision, I think, whether we choose to go that way. But I think to a large extent we've already made that decision by the discussions we've already had. So, I don't know that I have a problem with it, because I think it's already sort of implied by, some of the fiduciary discussions that we've been having.
Well, and on this point, ROLCA provides in subsection B1 that in a manager managed LLC, this duty of a member to provide information to other members becomes a duty of the managers and not the members. Yes. And that's not something that's in the RCW, but I think that would make sense to, if we adopt ROLCA A3, I think with regard to this ROLCA A3 duty, I think it would also make sense to adopt the part of ROLCA B1 that says that duty switches to a duty of the manager in a manager managed LLC.
Is that the distinction, or is it a matter of who you would have to provide the information to? And I'm thinking of if you have a manager managed LLC with a lot of members, and the members don't have a lot of responsibilities or activities, but one of them learns some really important fact that the LLC really ought to know about. Isn't the question whether they have to tell all the other members or whether they should tell the manager? And then the manager has the duty to disseminate that information. Because I can understand Michael's point that if you had an LLC with 150 relatively passive members, you wouldn't want to put on a single member the duty of having to share all that information, because that's not normally in the scope of what they have to do. But I think the idea that they should have to tell the manager that material information and then the manager disseminates it makes a lot of sense.
Michael, what do you think of that?
Well, I think this is in a context where another member is making demand on the company for information. And I think it's in a manager managed context, particularly with a company that has many members. I think adopting sub 3 in this context is inappropriate. To impose a duty on members that I think typically in that kind of context, they wouldn't have an expectation that they have a duty to provide that information to other members on demand.
Not on demand, though, because we're striking A2B, right? And so that demand provision is gone. We're leaving the A2A provision that talks about the duty of the entity to disseminate information that it knows is relevant. And I think what Teresa's saying is that if we pull in this provision, if I as a member know something about, for example, an action that's coming up, I'll have a duty to tell the manager, and the manager will then have the responsibility to disseminate that information. Is that correct, Teresa?
Yeah, but I don't think it says that. It says it's in the context of a demand by another member and giving
Yeah, I
information
think you're right,
to
Michael,
that
that it
demanding
doesn't
member.
say that. Yeah, it doesn't say that, but I was just trying to think practically. I understand the point, which is that if you have material information, you should have to share it with your fellow members in a member-managed LLC, because I think that's something of the point here with A3. In a manager-managed LLC, I think you should still have to share your material information. I think you just share it differently.
Well, and I think that's right, Teresa. I think you make a really good point, but I don't read the language to say that the member has to tell the manager.
And I don't either, and I think it maybe should.
Yeah, I agree with you. I agree.
I agree. And just importing it says they have to tell all the other members, because it doesn't make sense to me that a relatively passive member in a manager-managed LLC should have the duty, if they learn something important, to tell everybody.
But they should have a duty to tell the manager.
Is that right, though? I mean, does a shareholder have a duty to report to the board when they learn?
I don't think so.
You know, I'm not sure, but I mean, shareholders, do they have fiduciary duties merely by being a share? I don't think they do.
No, they don't.
LLC members
to me,
do.
Yeah.
But LLC members, don't they owe a fiduciary duty to other members?
Yes.
And also
very limited.
In the corporate context, whereas a shareholder may not have a duty to tell anyone, they are not able to use that information, I would assume. I mean, I don't know, maybe that's not insider information, whether you can use that information to profit. Maybe you can, I don't know.
Well, that's the securities law overlay. I won't go into that, I suppose, but I don't know. I worry a little bit about having any affirmative duty on a passive member in the member managed context, or excuse me, in the manager managed context. I fully agree in a member managed LLC, all the members are the same as managers. They should share information that's relevant.
I'm just looking up the part of ROLCA, Standards of Conduct, section 409. So a member of a member managed LLC owes to the company and subject to section 801, the other members, the duties of loyalty and care. And then it talks about how the fiduciary duty is about accounting to the company, refraining from dealing with the company with adverse interest, and refrain from competing with the company. And then your duty of care is to you can be regularly negligent, but you're not supposed to be anything worse than that. And you're supposed to have good faith and fair dealing.
Right, but look at what sub I in 409 does in a managed context to the members. And it parallels the point I'm trying to make.
And did we decide to adopt this without changes?
That's correct. And it's consistent with current Oregon law. So you have a duty of good faith as a member, regardless of management structure.
I don't have a problem with that.
No. I mean, that's what we adopted before, but I was just thinking about, does good faith require you to do what Teresa was talking about? If you're a member and you know important information, do you have a duty to report it to the manager? I'm just curious if that falls under this obligation of contractual obligation of good faith and fair dealing.
I don't know that I think it would, but I'm no expert in this area.
I don't know that it doesn't obviously mean that.
I think it would depend on the factual context. I think if a member had critical information that they were withholding, then I think you could look at the good faith provision here in 409, and there could be a case there. But it's different than having just the affirmative obligation on demand to give information, regardless of whether it's good faith, bad faith, or otherwise.
So do we, I guess, do we, the question, because it doesn't seem obvious, at least not in all instances, that a member would breach their duty of good faith and fair dealing if they don't disclose to the manager information that's important for the manager to know. Do we want to spell that out in this section 410, or do we want to just leave that to case law development?
I would like to see the latter myself.
Yeah, I guess I don't even understand what all the information that would be relevant for the manager to know means. I mean, because people can be passive members of an LLC and they can also be actively involved in managing a competing business, and there's no prohibition against that. That's perfectly legal. It might be really nice for the managers of the LLC that they're a passive member of to know everything that the entity that they're actively managing is doing, but I don't think we want to create a duty for them to just.
So can we take a look at 409F? And that talks about material facts, and then there's a comment. So 409F is on page 108, and then there was a comment about what material facts mean. And I wonder if that, okay, here we go. And this is on page, 114. So this is, okay. The information material, if there's a substantial likelihood that a reasonable decision maker would consider it important in deciding how to vote. So this seems to say that if there's a decision that's being made by the LLC, and this is true.
No, Roberta, that's the fiduciary duty issue, right? And so that's what Kyle was talking about, where I think where you have, for example, you have a passive member who's involved in running a competing business, you know,
Yeah.
and you can say, okay, well, why, yes, Kyle? You don't have to raise your hand, you can just talk.
Sorry, I was just going to say, I think F relates specifically to the duty of loyalty. So you're talking about conflicted transactions. Right. For members that have a duty of loyalty, which might not be all the members in a passive member setup, but when a duty of loyalty exists, then there is a duty of disclosure that goes along with that to disclose all material facts. You can't ask people to ratify a conflicted party transaction without giving them all of the material facts. But that's a very specific scenario that's much different than just relevant information generally to the business. I think that's how I'm reading that anyway, but I'm happy to be wrong about
that. So I at least am fine with not spelling out a duty of members to report to management of particular facts in a manager-managed LLC. And
yeah,
I
I'm
understand
fine with
most people seem to be on that.
Yeah, I'm fine with that as well.
Yeah, I mean, I think that makes sense. I'm persuaded by Kyle's comments that apparently this is often done where members of managed LLCs really don't have any obligations at all, and nobody expects them to have those obligations. It does make me think, though, that we need A3 for member-managed LLCs. We do not need A3 for manager-managed LLCs. So we probably need to revise that accordingly.
Well, yeah. So it seems like it would be easy simply to just say, to adopt A3 and add in front of that sentence, in a member managed LLC.
Yeah.
I don't have a problem with that. I mean, that's the context in which ROLCA places that duty.
If we're are we talking about A3?
Mm-hmm.
Because
Yeah.
A3 says at the beginning of A, in a member managed limited liability company, the following rules apply. And
Right.
So I don't think we need to say member managed again because.
Well, but we aren't adopting that we aren't adopting, A1, for example, or that introductory part of A that limits its application to
Okay.
LLCs. Because under A, we're only adopting A2A, and we're essentially saying that a member, regardless of the management structure, is entitled without demand to this information that's material to the proper exercise of their rights and duties. And then we're also going to say that the duty to furnish that information to a member is not only a duty of the company, or it's always a duty of the company. And then we're also saying in a member managed LLC, it is also a duty of other members.
Okay, I wasn't clear that we were getting rid of the language that says A, the following rules apply. I thought we were just keeping that and then getting rid of the demand part.
And can I just get one point of clarification on it? I know the default rules in a member managed LLC are that each member has equal rights in the management of the business. But that's the default rule, and you could still provide in a member managed LLC. I guess here's where I want the clarification, that only certain members would actually manage the entity. Therefore, you could actually have members of a member managed LLC that do not participate in the management and are actually passive members. And if that's correct, do we still want to impose upon them a duty that they disclose this information to their passive members? Because that's what you're essentially doing if we agree to this.
That's a good point.
Is there a difference between being a decision maker and being, I mean, if you want to be truly passive, you should set it up as a manager managed LLC. But if you're going to be a member managed LLC, you may not give yourself much authority to vote, but you should still have an obligation as a member.
Maybe. Like, I just worry about essentially passive investors who make a mistake and they're not a manager and they don't know about this, and they would expose themselves to potential liability. They enter into one of these LLCs and they're not managing it, and they have information that would be material to the transaction of the company.
Do you remember which section of ROLCA it is that says that you can sort of carve out certain areas of responsibility and say this?
I was actually looking for that, and that's kind of why I wanted to get that clarification.
Yeah, I just wanted to reread that part and remember whether it talks about whether that happens in member managed or whether that's only in manager managed.
So while you're looking for that, I'm still confused because I thought we were still using the same basic structure of ROLCA, which is, 410A member managed, these things apply to a member managed, and then B manager managed. So I guess I would like to be able to understand if we're not keeping that structure. I understand we're taking out some parts of it. How are we doing?
We're not keeping that structure. We're instead using RCW 25-15-136 as essentially the model.
Okay.
And
different
that statute doesn't adopt this ROLCA A and B system.
Okay.
And I think for those who are looking for the ability to alter, it's on page 24, the operating agreement may.
Thank you. That's so fast.
Sorry, where's that again?
Yeah, it's at the bottom of page 24 of the ROLCA. It's section 105.
D.
Well, D2, but that's not the authority to do that. That's saying if you did do that, if you did relieve a member of a responsibility.
Then I have duty of loyalty 409A.
Isn't this a combination of reading the section that says the default rule is that you have basically per capita management in a member managed LLC, but it's not one of the provisions that section 105C says you can't change, therefore means you can change that default rule?
I'm sorry, say that again. I apologize.
So the way that 105 is written, it says, here's the laundry list of everything you can't change, which means everything else can be changed. And then there's a provision that says, here is the default rule for per capita management in a member managed LLC. And that section is not on the list of things that can't be changed. Therefore, it can be changed. I think that's how you get there.
I think that's right.
And I think the provision that says in a member managed LLC, everybody has equal rights in the management is 407B2.
What page is that?
407B2 is on page 98. And it's not one of the items that you can't vary.
Yeah.
That's probably an area where a typical operating agreement is going to depart from ROLCA.
Right.
In terms of, a member's percentage interest also is going to equate with their proportionate voting rights.
Right.
I still feel like there's a different section of ROLCA that we adopted that specifically says you can carve out these areas of responsibility and absolve certain members of liability of having to do anything in areas that aren't their areas of competence. I'm on board with that concept of if you're a member who's been carved out of an area of competence that you don't have to do anything about, then I would agree you wouldn't have this duty that we're talking about to tell other members about the material information. I think that makes sense. I think we could come up with language to accomplish that objective, and I could do that, and sort of offline, and then propose it to the group next time, because otherwise wordsmithing it might be time consuming. But if people like that concept that I think Cliff was proposing, I think that's a fine concept. So I guess my question is do people like that concept of saying that this duty of a member to, and this is only in a member managed LLC, this duty of a member to provide other members information that's material to the proper exercise of those other members' rights and duties, that you only have that duty as to information that's sort of within your area of competence, or if at least you don't have that duty if you've been exempted from a certain area of competence under the operating agreement. Do people?
Or isn't it almost as if you're not treated as a, I guess, member manager in the member managed LLC?
Yeah, well, I mean,
that simple
as I understand this ROLCA power to carve out areas of competence, potentially, you might be as a member not responsible for aspect X of the company business, but you may be responsible for other aspects. And I would think that as to those other aspects for which you are still responsible, you would have this duty to report. Your lack of a duty to report would only apply to those areas that you are carved out as not having competence for. And
I
maybe
guess I would,
the operating agreement says you don't have any competency, you know, and no requirements, and then you would be completely absolved of the duty to report.
I guess I would argue to some degree that, you know, that subparagraph 3, you know, contains a knowledge qualifier in it. And to that extent, you know, if you're a truly passive investor or member, you really aren't going to have knowledge of any of that information, arguably. So I don't know whether you really need to worry about that. But, and I think, well, I would welcome wordsmithing, but I think that will be, that could be difficult to some degree. So, but I could be wrong.
So,
but you raised a good point about the knowledge aspect. It may be much ado about nothing.
Right.
I guess, David, I think of it in terms of even real estate transactions where you've got investors who are involved in multiple real estate deals, and they know maybe one is going on in one area and that is likely to increase the value within an area, and another LLC is looking at potential investment in that area, but all of a sudden put a duty on this member to disclose that, which could actually be adverse to his other LLC, and he may not even participate in the management. I don't know, I guess I can just think of scenarios where members that aren't participating in management may have material information. And so it's fearful of placing a duty on them.
I was just reading the question that that James put in the chat about whether this can be varied in the operating agreement. And I wonder if, and I see, Cody, that you say you're proposing that these should not be altered in the operating agreement, but I wonder if just a carve out for this part might be easier in terms of wordsmithing rather than trying to put in language just saying you can, for this particular part with respect to the information, a member's duty can be carved out in the operating agreement.
Yeah, whether the language covering this issue would be put in 105 or whether it's put in here, I'm agnostic about. Either would be fine. But I mean, I think, you know, whether it's unnecessary because of this knowledge element, as David mentioned, or whether we determine it's worthwhile to have this carve out if the operating agreement exempts you from having any management role in a certain area, I'm happy to say that would also exempt you from any reporting requirement to other members as to those areas. And whether that would be in 105 or here, I don't care about. But I guess I'm mostly interested is, does the group think that we need or should have that carve out? And if so, I'm happy to write up something that accomplishes that goal.
Did everybody speak?
I personally think the solution for Cliff's client is to only invest in manager-managed LLCs. And I think if they're accidentally wandering into duties to disclose information, they're not going to negotiate an operating agreement exclusion. You know, they're going to have stumbled into it anyway. So I don't know that it's worth doing.
I think on a practical level, this may come up in, you know, go back to our carpet layers, don't have an operating agreement. Looking at this in that context, is this an appropriate gap filler to their overall situation? You know, presuming they're member managed LLC.
Right, and I think under this, this carve out would only apply in the context in which maybe it's not in the form of a written operating agreement for those carpet layers, but maybe they've orally agreed that the one carpet layer is, you know, only going to go out and do the work, and the other one is going to get the bids, do customer service, all that kind of stuff, you know, do the estimates and that kind of stuff, and the other one's just going to do work. And maybe in that instance, you know, I mean, I don't really have a hypothetical for you. But I'm just trying to think of how would this affect your carpet layers? It only affects them if they've carved out areas of competence.
Mm-hmm. And it may be appropriate then.
Yeah, and I'm fine either way. So should we just do a quick vote on who thinks we should have something carving this out? Because I feel like I can't quite tell what the
Yeah.
mood of the
Cody,
room.
and I'm not even, I don't know on the practical side, to James' comment, whether it's necessary. I wanted to pose it. It's just top of mind thought. I guess I have more of an issue with just imposing potential personal liability on members in an LLC.
Mm-hmm. Well, I'm fine either way on this thing you mentioned. So
I'm a little confused. I just, because I'm going back. Sorry, I'm trying to track and going back. So A3 relates to the information under paragraph 2. Information under paragraph 2 is information concerning the company's activities and affairs.
yes,
Right?
and other
circumstances.
yeah.
We're not talking about like information about like, I have some information about one of the LLC's suppliers. Well, I mean, I'm trying to think of like something, I somehow know something that could impact the LLC's business, but really isn't about the LLC's affairs. Isn't this really trying to get at that in a member managed LLC, if I know about the LLC's affairs, I have to disclose that because we as, I and my fellow members are managing this business and I can't hide from them information about the business. That to me makes total sense. The idea that I might, maybe I know something else that potential, well.
So Kyle, I think
the kind of information that we're talking about is actually more limited than this conversation has suggested, but maybe I'm wrong about that. And if I'm right, then I have absolutely no problem with
Right. I mean, I think, Cody, the question before us right now is, do we carve this out to be limited only to manager-managed entities? Is that the question?
No, I think we already agreed that this duty to report to other members by members is only applicable in member-managed LLCs.
Right.
The question is whether in that scenario, if the member-managed LLC has carved out areas of competence among its members and saying, certain member A has no responsibility with regard to subject matters, X, Y, and Z, whether in that scenario that member has a duty to report information that's material to the proper exercise of other members' rights and duties with regard to areas X, Y, and Z.
Yeah,
that's the question. And whether we should put something in here saying that they don't have a duty to report in that scenario.
Yeah, I don't feel strongly about this either way. I don't know that we necessarily need to add something there. But does anybody feel strongly or feel like we need to add that language in? All right.
Okay, so we'll just leave that.
Moving on.
Okay, so the next thing is, and this is another thing that's in ROLCA but not in the RCW, and I thought it was a good thing. And this is section 410B4. And 410B4 says that in a manager-managed LLC, whenever this act or an operating agreement provides for a member to vote on or give or withhold consent to a matter, before the vote is cast or consent is given or withheld, the company shall, without demand, provide the member with all information that is known to the company and is material to the member's decision. To me, in some sense, this is very similar to that duty under A2A that we were talking about, and yet ROLCA clearly thinks it's different and additional information that a member is entitled to, and I can imagine scenarios where potentially it could be information not already covered by A2A. And so I suggest that we adopt this provision of ROLCA.
Yeah, I think it's just a mirror of the other one, and I'm fine with that. Does anybody have any concern about it?
It's fine.
Yeah.
Good.
Okay, and then next is moving on the RCW, then going to section 3. Section 3 of the RCW talks about how you can get certain information from the company that you're not automatically entitled to as of right. And in RCW, they list as the first type of information that you can get is the list of members. Well, that we wouldn't be adopting that because we've already covered that. But they also, what they say is what you can get if you jump through these additional hurdles is excerpts from meetings and records of the LLC action approved by member or manager without a meeting, and accounting records. I think that makes sense to adopt as to the meeting records and the accounting records. And so I suggest that we adopt RCW 2515-136-3 as it's written, with the exception of A. And then I have one other modification to it, but I wanted to see what people think about doing that. This is additional information you can get if you jump through the additional hurdles.
Yeah, I'm generally fine with adopting 3, with provided that we also adopt 4.
Yes, and 5. I also propose
5,
that we adopt
yeah.
RCW 5.
Yeah, and so what 4 talks about, for those of you who don't have it up, it's the why part of it. The member may inspect and copy the records if they seek a purpose reasonably related to their interest in the LLC, and a member makes a demand describing with reasonable particularity what they're looking for, and then the records are sought are directly connected to the member's purpose. So no like annoying fishing up expeditions, right? So I think that's fine.
Right, and I'll just point out that the hurdles you have to jump through in RCW 4 and 5 are identical to the hurdles you have to jump through under ROLCA B 2 and 3.
Yeah.
Yeah,
I mean, I'm generally fine with 3, 4, and 5 with that one caveat because we've already addressed the list of members.
Right, one other, so the only change I have to RCW 3 is to add another category of information that you can get if you jump through the hurdles. And this category of information is actually what ROLCA talks about as the only category of information, which is any other records regarding the activities, affairs, financial condition, and other circumstances of the company as is just and reasonable. So Washington essentially is telling you the only records you can get if you jump through these extra hoops are the meeting minutes and the accounting records. And ROLCA says you can get any other relevant information as is just and reasonable so long as you can jump through these hurdles. And so I think that makes sense. I don't know why we would limit it only to meeting records and accounting records if people are able to jump through these hurdles and show that they need this information, it's connected to their purpose of a member, and they describe it with particularity, that they should be able to get it. And I don't know why we'd limit it to only those 2 categories. So that's my only change from RCW 3 is to add that language from ROLCA B2. Other records regarding activities, affairs, financial condition, and other circumstances of the company as is just and reasonable.
I mean, I don't know in what circumstance a record is going to be just, but I think in the broader scope of sense, I think it mirrors what we've already agreed to in A2A, right? Which is a big any information concerning the company's activities. So I think it's fine.
Okay. Does anyone else, does anyone disagree with adopting 3 with the addition of that language from ROLCA B2?
I guess I don't disagree with that philosophically, although I do look back, and I guess I would like to know where we stand on 105C8 of the ability to draft the operating agreement in this area. Are we going to retain?
Michael, I think that isn't that, Sandy, within the scope of what we need that other group of folks to think about it from a policy perspective?
Yeah, it's just that I view it as really issues that are intrinsically connected. And it's hard to make a decision in isolation on 410 without knowing where we're going to end up there.
I think we can put a pin in it and say, you know, if we go this way, then that's the route we take. And if we go this way, then that's the route we take. You know, because I do think you're right. It ties back to that policy question of, you know, what is the scope of this?
Yeah, because I think Cody's approach makes sense, particularly if we're looking at these as default rules. But to be handcuffed completely without the ability to draft appropriate provisions in the operating agreement, then I would have some significant concerns here.
Yeah, no, I think that's reasonable.
And, you know, we hadn't specifically talked about 105C8 before. I do agree it's one of those things that we probably need to also talk to the political people about. And as you may have seen from the chat section, or I think Roberta commented about it earlier, but ROLCA allows you a substantial amount of leeway to limit these rights of access to information, whereas current Oregon law and the RCW don't allow that, which is something which is what I propose as well. So, and my understanding of the sense of the room. Go ahead. But I thought we could cover that waiver power at the end. My understanding is people are on board with RCW sub 4 and sub 5, which are basically the same as the ROLCA provisions of B2 and B3. All right, so we'll move on to RCW sub 6. This is having to do with dissociated members, and ROLCA has a different provision. So RCW says that the dissociated member can get the records that are mandatory to be maintained and that you have an automatic right to if it relates to the period in which you were a member or a transferee and you're seeking the records in good faith, and you jump through all those hurdles that we just talked about of you need to have it, be seeking it for a purpose that's related to your membership interest, and you have to describe the records with particularity and so forth. So it's sort of, you get additional hurdles if you want records and you're a dissociated member. That's what RCW says. ROLCA talks about how it also says as a dissociated person you have to make a demand, and then ROLCA says that you may have access to the information to which you were entitled while a member if it has these same requirements. So it's very similar, but ROLCA says that this right of a dissociated member to information is subject to subsection H, and subsection H of ROLCA is something that we'll end up talking about more as we work down our list, but it is talking about how the limited liability company can restrict use of information to be furnished, such as designating it confidential, imposing non-disclosure obligations, and so forth. And RCW doesn't have that express carve out of subject to subsection H. That's the core difference. RCW talks also only about records, whereas ROLCA talks about information. And it strikes me that, sometimes I think we should probably be talking about both information and records rather than only referring to the one, because some of the duties of information sharing are about records and some of the duties are about information. And I think we should be encompassing both when we're talking about, when we're referring back to the kinds of things you have a right to know. So you can see in sort of that Word doc I sent around what I'm proposing, essentially that we adopt the RCW. What do people think? I mean, it's pretty similar.
I agree with that, and I'll tell you why. So I don't think that, I think the restrictions that ROLCA puts on former members' access to information could be really problematic if you have an IRS partnership audit. And you're not dealing with it in the review year, but which is the year that you get the audit notice and the audit takes place, but in fact you're dealing with it, the audit year, the adjustment. So you have the review year and you have the adjustment year, right? And so the idea is that IRS can come in and audit in 2021 activities that occurred in 2019, but you may have a different partner group composition right there. And so, I want the people who are, if they push it out to the 2019 partners and someone's been dissociated, I want them to have the ability to have access to that information. So that they can say, defend against the audit, and know why certain positions were taken on the 1065 and things like that. So, so I don't want to unnecessarily limit dissociated partners' reasonable access to information. And I think ROLCA puts, maybe from my perspective, maybe too many limitations on that.
So, I mean, in terms of the hurdles you have to jump through, I think that they are essentially the same between RCW and ROLCA.
Yeah, it's just that H puts that additional reasonable restrictions language, and I don't like that. I like the language that you proposed more, with the removing H there. And I know I'm skipping ahead in the discussion here, but I do like your proposed language there with the adjustments to RCW 2515-136 sub 6.
Okay, yeah, and the other different, so they, apart from the reference to subsection H, the other key difference is that RCW gives dissociated members only the right to that automatic required information, whereas ROLCA gives you the right to all the information that you would have as a member, which, as we've talked about, as we've adopted various provisions of ROLCA that aren't in RCW, can be a little bit broader than that if certain showings are made and so forth.
Yeah.
So I guess, does anyone have any disagreement with doing what I proposed in that Word document, which is basically adopting the ROLCA C, but delete the reference to section H and otherwise talk about information and records rather than only referring to one of those types of knowledge?
I think I'm fine with that. Right.
Yeah, I think it's good to add information in addition to records. That's really appropriate.
Okay, so I'll move on to RCW 7, which is the same as ROLCA D. And I think we should just adopt it. Okay, so then moving on to RCW 8. This is similar to ROLCA H. And RCW just says the LLC may impose reasonable restrictions on the use of records and information obtained under this section. And ROLCA goes into much more detail. It says, in addition to any restriction or condition stated in its operating agreement, because it allows you to do that in 105C8, whereas Washington doesn't allow that. ROLCA says a limited liability company, as a matter within the ordinary course of its activities and affairs, may impose, and this now it's similar, may impose reasonable restrictions on access and use of information to be furnished under this section. But then ROLCA goes on to say, and I actually think this is helpful information and helpful to include, including designating information confidential and imposing non-disclosure and safeguarding obligations on the recipient. In a dispute concerning the reasonableness of a restriction under this subsection, the company has the burden of proving reasonableness. I think that latter language from ROLCA is good and would propose that we modify the RCW to add that latter language. Essentially, the difference between my proposal of what we should do and ROLCA is we're getting rid of the, in addition to any restriction or condition stated in its operating agreement. We're also getting rid of this language that the LLC can impose these restrictions as a matter within the ordinary course of its activities and affairs. Those are the two changes from ROLCA that I am proposing, and both of those changes are part of RCW as well.
Cody, I guess I have a question on why it's appropriate to strike the preface phrase in sub H relating to the operating agreement.
That's consistent with my ultimate proposal and the RCW that says, and the current ORS, it says you can't change these rights of information.
Let's be clear though, the current rights under Oregon law are only to certain categories of information. So we are broadening the categories of information. So I think it's fair game to talk about whether we should have that be subject to an opt-out in the operating agreement. I, for one, think there should be a limited set of information similar to what's under Oregon law now that's mandatory, allow the operating agreement to tamp things down on the broader picture. That's just.
And so, I mean, I guess, maybe this first clause about in addition to any restriction or condition stated in the operating agreement, it seems to me that is something that whether we adopt that language or not is really dependent upon what our ultimate decision is about section 105. And so maybe we sort of put a pin in that and either we strike that or we adopt it depending upon what we decide in 105.
Mm-hmm. What do you think of that, Michael?
Can we include the preface language and put in our draft and then come back to this when we talk about 105C8?
Yeah.
I agree with James's point here. So.
You're taking notes, right? That on all these things that we're going to have to talk about once we go back to 105.
I am.
Okay. Okay. Good. All right.
What did we decide?
We're
going to put a pin in it, and we're going to come back to it after we talk about 105.
Yeah, it kind of feels like we're cherry picking whatever provisions would be the most transparent, whether it's out of ROLCA or RCW, and combining everything into one statute. I'm curious, once we're done with this, if we can just get a red line of ROLCA versus whatever we end up with, and then maybe have another short discussion on it.
I think that's a good idea. I mean, we're going to have to involve legislative counsel in those discussions anyhow, right, about the whole drafting process. But I think particularly in light of in this section and in some of the other sections, it would be useful for us to be able to give Sean Brennan, who we're working with there, here's what we think would be a good model, provided you can make it conform with the form. So.
Yeah,
okay.
Valerie, I'll work with Cody to make sure that I have a good understanding of what the ideal drafting of these sections would be. And I'll run it by Sean specifically and see if we can get at least something that we could have reviewed by the 105 folks sooner than later. Is that,
Yeah, I
is that
mean,
the plan?
now I know they're swamped with the second, who knows how many sessions we're gonna have,
Well,
but
the second one's over somehow.
yeah, yeah.
No, I hear you though, but we'll at least try to get that language. Let's get that. I'll work with Cody to make sure that we get that language at least as something that is coherent for review, and then we'll go back to 105 to make sure that we're
Yeah, and we'll circulate that by the group too, just because I know that, I don't want us to accrete too much around 105 before we, make or get to a decision on the policy issue. So
yeah, agreed.
Let's try and get through the rest of this, because there's not that much left to get through, and then we'll take a short break and then come back and start with Teresa. Okay.
Sounds good. And I will circulate sort of my notes from our discussion today. I'll send them to Sandy, and then Sandy can send to people. And just at least, regardless of what Legislative Council will do, at least we can know and make sure we're all on the same page about what we've agreed to.
Yeah.
I think that's smart. Yeah.
So next is RCW 9. LLC may charge a person that makes a demand under this section reasonable costs of copying limited to the costs of labor and material. This is similar to ROLCA E, and it's also similar to ORS 63773. No, I said that wrong. 63777 sub 3. I think we should adopt this with one change, which is ORS 63777 sub 3 contains an additional sentence, which I think is good. The charge may not exceed the estimated cost of production or reproduction of the records. I think that's a good check on ensuring the cost is reasonable. You give an estimate to the person, this is what it's going to cost you if you want these records, and they can make that choice whether they want the records or not, but then you can't sort of upcharge them after the fact.
$1 million.
So I would propose that we adopt RCW sub 9 with the additional sentence that I just mentioned from ORS 63777 sub 3.
I think that's reasonable.
And that's consistent with ROLCA.
Yeah. With the
addition.
Don't charge them $1 million.
Right.
Valerie,
Exactly. I'm glad someone got the reference.
Oh. Who does ROLCA work for? Okay, RCW F and RCW 10 is got some similar stuff from ROLCA F. This is about how you can a member. So RCW says that a member or a person dissociated as a member may exercise the rights under the section through an attorney or their agent. Any restriction imposed under the operating agreement applies to the attorney and agent as well. ROLCA says that a member or person dissociated as a member may exercise the rights under this section through an agent, or in the case of an individual under legal disability, a legal representative. Any restriction or condition imposed by the operating agreement applies to those, the agent or legal representative. So they're very similar. Mm-hmm. But RCW doesn't talk about legal representatives, and it doesn't also talk about conditions that the operating agreement may have. I know we are talking about whether the operating agreement can have these restrictions or conditions. ROLCA, I mean, I know attorneys are agents, but I also think it's helpful sometimes to make that explicit. And so, my proposal here is to use ROLCA subsection F as the template and specifically reference attorneys in there as a type of agent, and then to delete the reference to the operating agreement being able to, restrict rights of access to information. And given our discussion we've had so far, I think that striking the language about the operating agreement is something that we would be putting a pin in, depending upon whether we adopt, C 105C8 or not.
You anticipated my next comment.
Yeah.
And I won't belabor it.
So with keeping that pin in mind, are people fine with the adopting ROLCA F and adding the language after agent, including an attorney?
Yes.
Okay.
Subject to caveat.
Yes. Okay. Next is RCW 11. The rights stated in this section do not extend to a person as transferee, but the rights under subsections 2 and 3 of this section, which is talking about how you can get that automatic information, as well as if you jump through the necessary hurdles, you can get more information. That those rights may be exercised by a deceased member's personal representative for purposes of settling the estate, or by the legal representative of an individual under legal disability who is dissociated as a member pursuant to statute. And this is similar to ROLCA G. And ROLCA G, though, is way shorter and simpler. It just says, subject to section 504, which is something that Teresa will be talking about soon, the rights under this section do not extend to a person as transferee. So key differences include RCW doesn't talk about legal representatives. Or I mean, to say, I was reading the wrong part of my notes just now. In part, I think this will depend upon what we do with Article 5. Okay. I like ROLCA G better than what the RCW says here. I do have one potential change to the ROLCA G, depending upon what we decide in Article 5, but otherwise I would just adopt the ROLCA G.
Can I jump in here? Because what Washington did basically was in section 504(2) of ROLCA, they just didn't adopt it in section 504(2). They just put it in section 410. It's so right now what 504(2) says is, for purposes of settling the estate, the rights of a deceased member, the legal representative can exercise the rights of a deceased member under section 410. What Washington did was just simply clarify in RCW 2515 136, 10, that the legal representative can do it. In other words, they just put the same thing in 410 and instead of 504, because they thought it made more sense there.
That's on page 130 for those of you who want to look at it.
Yeah, sorry. So, I mean, I think the concept is right, which is that if someone dies, their legal representative ought to be able to have their information in order to be able to wrap up their estate. Washington just put it in 410 instead of in 504. I would probably leave it the way ROLCA did it and leave it in 504.
Yeah.
Only because that will be where people from most other states will be looking for it. But there's not a policy distinction here. They both did the same thing.
Right. Yeah, I agree with you. I think it's better to keep it in 504.
Yeah.
That extra verbiage.
Works for me.
See, and there we've just done half of 504. See how we did that?
Let's not jinx ourselves, Teresa.
Cody, could you say a little bit more about the reference, if we're ready to move on to this point, the reference to 503B1? I want to hear exactly what you're after there.
Sure, and I think it's something that, probably we'll not make a decision on until we've talked about 503 in more detail. This has to do with charging orders, right. And section 503 says that to the extent necessary to effectuate the collection of distributions pursuant to a charging order, the court may appoint a receiver of the distributions subject to the charging order with the power to make all inquiries the judgment debtor might have made. My own thought when we get to 503 is I don't see the point of appointing a receiver to collect the distributions. I would think you would just give that right directly to the creditor and then let them make the inquiries rather than have a receiver make these inquiries that the debtor might have made. And so my thought is that as we're looking at this sort of ROLCA 410 concept, that that because there is this ability for a non-member to ask for information, specifically a creditor, that I would have a carve out in ROLCA 410G for that creditor. So subject to 504, which is, what if someone dies, then they can get the information. Similarly, subject to 503B1, as I would propose it to be adopted, that they also would, even though they're a transferee, be able to obtain information. And again, that would only be after a court allowed it, but
yeah, let's table that until we discuss 503 on charging orders, because there are good reasons why you would want a receiver sometimes to exercise that right rather than have the creditor exercise that right directly.
Okay. Well, and this receivership is permissive here. The court may.
Right.
So I agree. We should, I don't know, maybe excise this language and, keep it in an asterisk or footnote and, come back to it when we hit 503.
Yeah, I put a note next to 503B1 that once we get to it, we need to circle back.
Okay. So then the next part is RCW 12. It basically gives managers the right to get all the automatic information, as well as at a reasonable location specified by the LLC. Any other records maintained by the LLC regarding the LLC's activities and financial condition or that otherwise relate to the management of the LLC. I think that is good. And the only a difference that I would propose is when RCW talks about how the manager can get this information, it says each manager or each member of the manager, if the manager is a board, committee, or other group of persons. And it strikes me that if your manager is, another LLC or something like that, then that other LLC should be deciding how it wants to exercise its role as manager and which of that LLC's members or managers should have the right to get information about this LLC that they are managing. I don't know why we would be telling that other LLC, which is the manager, how to do their job in terms of divvying up information among their members and managers. So I was proposing to strike that. Maybe that's anti-transparency, but I don't really think it is too much.
Is this really talking about a manager? Is this really talking about a manager that's an entity, or is it talking about a manager that's a group of persons? Like we do all the time that are managed by a board. And so you might have 3 or 5 individuals on that board. And I think this is just trying to clarify that any of them individually can access it rather than needing 3 out of 5 to vote to access.
Oh, okay. That makes sense. I misunderstood.
In other words, 3 from blocking the 2 from getting the information, which I think any director or manager needs full to perform.
I agree with that. I had misread it. That makes sense. So I would propose then just adopt RCW 12 as it's written.
Yep, works for me.
Okay.
Thanks, James.
Thank you. Yeah, that's an excellent catch. I should have caught that. So the last part here, but it's not ultimately the truly last part, is RCW 13. Any action to enforce any right arising under this section must be brought in the superior courts. We don't have superior courts, and I don't think we should adopt that provision. But I do think that we should maintain something which is not referenced at all in ROLCA, and which this RCW provision is alluding to, which is ORS 63781, court-ordered inspection of records. And I propose that we just adopt 63781, either as a separate statute or as subsection 13 of whatever we're going to call our version of 410.
It seems relatively non-controversial to me. I mean, you need to have a process, right?
Sorry, say it again.
No, I think it seems relatively non-controversial to me. Aurelia, Kyle, do you have any concerns?
No, I like ORS 63781. I think it's useful. I've used it to enforce record inspection rights. So I think there needs to be a provision for that.
Yeah.
And I guess the only change I would have is, the ORS talks about records, and I would just have it include information as well.
Yeah.
Yep, I agree. That makes sense to me.
Okay. All right. You want to talk about H?
ROLCA H we already talked about. Yep. There's a couple parts of ORS that aren't in what we've talked about already that I wanted to mention to the group. One is ORS 63777 sub 2 says the right to copy records includes, if reasonable, the right to receive copies made by photographic, xerographic, or other means. I feel like that's sort of implicit. Like maybe we can put that in a comment or something, but I don't know that we need to adopt that as part of the statute anymore.
Agreed.
I would only be in favor of requiring it if we add the word mimeograph too. No, I think that's a good addition.
Okay, so I'll mark that down, that we'll adopt that as a comment. And then ORS 63777 sub 4, it specifically talks about how the duty to provide the list of members, that you comply with that duty if you give a list that was compiled no earlier than the date of the member's demand. I don't know whether, I just don't know that that's necessary to have. Maybe the theory is that, to me, when we already have the rule that you have to give a current list, so you're going to be giving a current list. It's got to be at least, I think, inherently as of the date of the demand. Maybe things, and you also have to give past information. So I just feel like 777 sub 4 is unnecessary, or
yeah.
So I was just going to not have it be part of what we're doing going forward. And then the last provision is 63771 sub 3, which says failure of the LLC to keep or maintain any of the records and information required pursuant to this section shall not be grounds for imposing liability on any person for the debts and obligations of the limited liability company. I think essentially saying that just because you don't keep or maintain these records doesn't mean that you are subject to veil piercing. I kind of feel like that's already inherent anyway. And I also feel like, I want to say there's some other provision we've already adopted of ROLCA that talks about not these formalities, not observing them doesn't subject you to veil piercing anyway. So I think it's kind of unnecessary, but I also don't care if people think we should have it.
Well, I'm fine putting in the comment because I think it gets to Michael's carpet layers, right? We don't want them to have a foot fault here and then, additional liability.
So should we put all three of those things I just talked about as comments?
I'm fine with that approach myself.
Okay.
I think there's so many changes. I just need to take a look at it. With respect to H, I know you said we had already talked about it. I just was, I guess, having a discussion with James. But what was the consensus on H?
The consensus on H was to use, well, I'll just tell you the language we were going to adopt, and you can see that it is mostly similar to the ROLCA H. So at the very beginning, we have a pin in whether we're going to use this language or not, depending upon what we decide on ROLCA 105C8. In addition to any restriction or conditions stated in the operating agreement. So that's the sort of disputed language. We move on from there to say, the limited liability company may impose reasonable restrictions on the use of records and information obtained under this section, including designating information confidential and imposing non-disclosure and safeguarding obligations on the recipient. In a dispute concerning the reasonableness of a restriction under this subsection, the company has the burden of proving reasonableness.
Yeah.
Yeah.
And I agree with you, Cliff. I do think that we need to look at a markup of this. So we'll work on getting that and circulating it, because I think we've talked about a lot of stuff involving this section.
Yeah, I feel like this is the most marked up section we've had.
Yeah, I agree.
Yeah.
And I'm kind of trying to figure out why we're doing that so significantly, but we'll take a look at it.
Okay. And that's it.
Fantastic. Thank you, Cody. Good job.
Thanks, Cody.
Oh yeah, thanks. Thank you all.
Cody, if you send me your notes, I'll compare them with my notes, and I'll distribute those as like a draft not to be distributed out to this group, just so we can all take a look at it together, make sure we're on the same page before we even send it to anybody else.
Yeah.
Yeah. And I think it would be helpful. Sandy takes the form of almost a red line as between the RCW and the version. So
I'll do that. I'll put the RCW, perfect.
I have 11 o'clock. Why don't we take a 7-minute break, 5-7 break, because I need more coffee. And then we will come back and we will get started on Article 5. Finally,
Yay,
I'm
Teresa.
so excited. Go team. Okay, see you in a few minutes.
Good work. Thanks, Valerie.
Nick? Is this your wiggle? Is this Lauren's or yours or what?
Hey, Valerie.
Yes.
Hi. I'm going to have to sign off. I've got another meeting I didn't realize I have. So I'm going to catch up with you guys later.
All right. Thank you. I appreciate you as always, Susan.
Thank you very much. And you did connect with Lane on more information about the remote notary piece?
No.
No.
Okay. Well, Lane and Valerie, please connect on the remote notary piece and
What don't we know? I haven't heard anything.
Okay. I guess my understanding is I think it's the business law section wants to do an article for their newsletter.
Yes.
Oh.
And they wanted to talk about the remote notary, and then Lane, maybe you can give her some additional information about the remote attestation piece that you had been working on.
That didn't pass.
That didn't pass. I know.
Yeah.
Sorry. Okay. Goodbye, all.
Bye, Susan.
Hey,
Bye.
Sandy, you are a Zoom monster today, aren't you?
Seriously.
Yes.
Well, Lane, you're gonna be too, because we have another meeting at 1.
Yeah, I'm just kind of listening in. I got it on video off and getting some work done here at my office, just listening to the conversation. You've got to be attentive to 2 of these meetings in one day. Wow.
Doing my best.
Yeah.
Well, I'll reach out to you, Lane. And I know that they were planning an article because we had Brenna Dickey at Miller Nash on sort of the comparison in Washington's remote online notarization approach. So I
Let me know if I can help.
Thank you so much.
And Valerie, and on Ron, and Lane, we're gonna need to go back in the next session and actually get it passed permanently. So
yeah,
right.
Whatever support I don't think we're gonna have a lot of people against it, but just building up some support ahead of that, it's gonna be good.
No, I was disappointed that the remote attestation didn't go farther.
We're not giving up.
I know.
I talked to Susan, and we can talk about this in the other group, but I don't think I think it actually might be worth trying to get through in 21.
I agree.
Yeah, and the bill has been approved by the commission, so it's something we can just go for.
Yeah, it's there. It seems like it's worth introducing. It's a good companion piece to the remote notarization.
Yeah, absolutely, and particularly given the crazy landscape we find ourselves in. And Michael can certainly attest to this. Our clients who are on the estate planning side are very, very concerned. So.
Absolutely. Right.
And we're going to at least try to look at e-wills. So that would be another addition to it.
Brave new world.
Seriously. It's one of those things where I was thinking about this the other day, how, our younger attorneys, the sort of the millennial types, had said, oh, we need to get this, we need to get this, we need to get this. And so the firm had taken some steps in that direction, but they were completely right. So.
You mean our new young attorneys who didn't have to take the bar exam this year?
No, somewhat older than those. I haven't interacted with any of those, actually, so.
Yeah.
I will say, just to defend folks, most of the students did take the bar. I know, sincerely. I don't think, at least the folks I've heard about from here.
I mean, I think we can all agree the bar exam is kind of a stupid waste of time, but there needs to be some sort of licensure process. So what the appropriate thing is, I don't know, but
one of the things that was brought up in the faculty is that part of the bar exam, the benefit of the bar exam is the sort of the interim effect of, oh my God, we better learn this stuff because it's going to be on the bar exam.
Yeah,
and the students this year already had that, right?
I mean, ask me how many times I've answered a riparian rights question.
Oh, I know. And also, let me ask the practitioners in the group, how likely is it, except in the context if you're standing in court and needing to make an objection, do you answer a client's question off the top of your head without doing any research?
Well, fairly frequently, depending on the question, right? But my biggest problem with the legal education, and I will say too, because I'm teaching in the graduate tax program right now, with tax education, is that it doesn't prepare people to be practitioners. You know, and so if there was some way to bridge that gap between the theory that you need to know and the actual skills you need for practice, I think that should be included in licensure. So
that would be an internship program.
Or indentured servitude. I mean, like they have in England.
Yeah.
Right?
Well, okay. Yeah. Basically the same thing. Okay.
So
I'm
anyhow,
gonna go get my
this
coffee.
is my personal soapbox. I feel fairly strongly about it, but
yeah, good. All right. I'll be right back.
Hey, Valerie, just so you know, I'm gonna have to jump at 11:30. I've got a board meeting.
Sure. No, I really appreciate your joining us. I know that we hadn't originally planned to have an August meeting, but with all of the craziness involving COVID, it's nice that so many folks were able to join us, and I feel like we made really good progress. You know, largely thanks to Cody to get through to where we are now. So, and I'm so excited that we're going to start Article 5. We've been having poor Teresa be ready on this for like 3 months now.
That's all right.
So just, and by the way, I don't know if everybody saw the exchange between James and I about the carve out. That basically would allow companies, LLCs, to withhold the names and addresses that was in the RCW. But I had an email exchange with Brian Todd, who chaired Washington's committee, and that was his responses to exactly why. And you know, I think James' point is basically like, we're never going to have any funds set up here in Oregon, given our laws, and this is just one more reason that we're loading on why a fund wouldn't want to set up its entity here. And as long as we're fine with that position, you know, I think it's fine to keep that carve out. But if we do want to make it more business friendly, then we may want to include that carve out.
Yeah, Cliff, I think that is helpful. Can you shoot me an email just about that, so I remember when we're circling back and trying to talk to the sort of policy people, that we remember to raise that issue? Because I think that is something that we brought up when we did the proposal, but I think it's something that we do need to circle back on when we run into these things that could have an impact either way.
Yep, will do.
Thank you.
James, did you have anything else to add on that point?
No, I think you covered it. Yeah. I mean, and honestly, I think we'd have to go a lot farther than just that one section if we really wanted to try to draw private equity back. It just doesn't seem realistic. I mean, it's unfortunate, but we're just not going to have Oregon entities in that.
Yeah, to that point, I think it was in our back and forth. It's just adding to the list.
Yeah, I'm going to keep, and that everything from the chat box, it gets recorded along with the not the private stuff, but the public chat gets recorded along with what I have for the recording. So I'll also make sure that's included in the notes, just a description. All right, Valerie, think we have everyone back?
Yeah, think so. Ready, Teresa?
I'm ready. Shall I get started?
Please.
Okay. Well, let me start with an overview of Chapter 5 to tell you what I overall think about this, which is the vast majority of what's here is consistent with what we already have in Oregon law. To the extent there's stuff in RLCA that's not consistent with Oregon law, I actually think it's a vast improvement and I'm in favor of it. So I want to just kind of give you that broad scope right off the bat, that we're not looking at making some wholesale changes here. We're actually making some improvements. There is one place where I think this differs from some Oregon case law, and we'll talk about that when we get there, when we get to charging orders. But I actually think the RLCA approach makes a lot of sense. And given why the case was decided the way it was, I think it's probably okay to change that and go with what RLCA says. So that's our big picture. There's 2 small sections and 2 large sections to deal with in Chapter 5. The first of the small sections is Section 501. The analog to that under Oregon law is ORS 63-239. And the primary purpose of this is to say that a transferable interest in an LLC is personal property, can be dealt with as personal property. Oregon law already says that a membership interest is personal property. Draws a distinction here between a membership interest and a transferable interest, I think only because transferable interest is a defined term under ROLCA, and it's defined in section 24 of, or subsection 24 of section 102, which is on page 11. And your transferable interest is defined as your right to receive distributions. So it's not all of your rights as a member, as an LLC member, but it's your rights to receive any money or financial benefit from being a member of the LLC. And this is one of the things that I think conceptually ROLCA does a lot better than Oregon's existing LLC statute, which is that it takes the concept of the bundle of rights that an LLC member has and it divides them out into the part a creditor can get or a transferee can get, and the part that fundamentally belongs to the member. And ROLCA just does a much better job about respecting the rights of members of LLCs to pick their partners, to pick who they're in business with. And I think that really comes about because when Oregon originally wrote its LLC statute, it probably didn't think much about what happened on the back end when things go sideways, because often people don't. And the experience over the last couple of decades, almost 3 decades, has really shown that there's a need to do that because not everybody wants to be partners with a bankruptcy trustee or a bank or someone's ex-wife. And it's one thing to give them money and it's another thing to be partners with them. And so what Article 5 does, I think, better than ORS 63239 is it talks about the transferable interest rather than the membership interest. Conceptually, I think it's the same idea, which is we're treating it as personal property. It's something that can be transferred, but it is, I think, making it clearer that we're talking about some of the bundles of rights and not all of the bundles of rights. The difference between ORS 63239 and I keep looking to the side because I have it open on a different screen here, so I'll try and move that so it's not as distracting, is that ORS 63239 also clarifies that a member is not a co-owner of and has no interest in the specific company property of the LLC. To me, that's kind of an obvious fact. ROLCA doesn't put that in there. I think the most similar thing ROLCA has is in section 304 when it says that members aren't responsible for the debts of the company. I think the corollary to that is the members don't own the company's property either. I don't know if we want to keep that section, that sentence out of ORS 63239, or if we just want to put it in a comment. I know we want to clearly give the signal we're not changing the law on that issue. So I think at a minimum, it should be in a comment. I think it's kind of obvious and we don't need to say it, but if people feel strongly that we should say it, I would add that.
So Teresa, I mean, if you look at 63239, it looks like it hasn't been changed since 1993.
Right.
Right. And so I think it's probably vestigial from when they were first trying to figure out like what is an LLC, would be my guess.
Valerie, you're correct. The 93 Act was sort of a meld of the Corporate Act and the Limited Partnership Act at that point, and with some partnership facets there. So I agree with Teresa's approach, maybe mention it in a comment that we're not intending to change that, but it does seem fairly obvious at this point.
And also in the distribution rules under 400, and I couldn't quite find which one it was, it states that members on distributions are not entitled to any particular property, right? And so that's also consistent and sort of inherent in the whole idea that members don't have an interest in a particular property.
Right. Yeah. I think that's right. I would favor putting it in a comment just to make it clear to people we're not planning on changing the law here. It's just we don't feel like we have to say it anymore.
I agree.
Okay. The comments to section 501 make clear that we're really only talking about the rights to distributions. And if a membership interest is transferred, that does not change the governance necessarily. And that's an important concept as we get into section 502 and we talk about what's it mean when you transfer a transferable interest. The point in the comments here is that when you transfer a transferable interest, the ownership changes, the governance stays the same regardless of how that's transferred. So if you're using the default rule and it says you have a company that's owned by 3 people and each of them has, 1/3 of the membership rights, and one person transfers their interest to one of the others, now the 2 that are left are 50-50. They're still per capita. They don't become 2/3 governance and 1/3 governance. That, of course, can be varied. That default rule can be varied in the operating agreement. And I think for people who write these and want to vary that, they'll want to know that they should decide what they want to do about that if someone transfers an ownership interest. But I think that's a drafting consideration for people who are putting these together rather than anything that we would change in the statute.
I agree. I like the simple math of it too.
So that's section 501. Unless anybody has any other questions, I think we just adopt ROLCA as is.
Yeah, I agree.
So let's go to section 502, which talks about the transfer of the transferable interest and how this works. And the analog to that under Oregon law is ORS 63-249. And I think the way to approach this particular section is to go through it one by one, each subsection, because some of these are pretty much exactly or very similar to what we already have in ORS 63-249. But there's some new ones and we can point them out along the way. So starting with subsection 502A1, it says transfer of a transferable interest is allowed. And that's really the same as ORS 63-249, which says a membership interest is assignable in whole or in part. So I think we keep that as is in ROLCA because it's consistent with what we have in Oregon law. In subsection 2, it says it does not cause a person's disassociation as a member or dissolution winding up of the LLC if you transfer your transferable interest. And that's essentially the same as 63-249 sub 2.
Is there any nuanced difference between transfer and assign?
I don't think so.
Yeah, I don't know.
Assign sounds like it's a voluntary transfer where a person may choose to sell their economic rights under their membership interest, but very often LLC membership interests or the transferable part of it gets transferred by means that are not voluntary. For example, when someone files a bankruptcy, their transferable interest automatically transfers to a bankruptcy trustee. Or when they're put in receivership, it automatically becomes subject to what the receiver is going to do with it. We'll talk about transfers of ownership interests beyond charging orders when we get to the charging order section, because that's kind of an interesting topic. But I think transfer is broader than assign because it includes involuntaries.
Well, I mean, someone who gets a membership interest by right of the death of the member, that's not exactly voluntary, and they become an assignee. So, I mean, I think that my reading ahead says that they address the situations that I would be concerned about, but I'm sure we'll talk about it as we go through.
Yeah, I actually think ROLCA did a really nice job of covering a lot of the areas that were open and confusing there. I think ROLCA is a little bit clearer than 63-249 too, because it not only talks about it doesn't cause a dissolution, but it also says it doesn't cause a disassociation of the member. disassociation is a separate process. So I think that aspect of A2 is an improvement over what we have in Oregon law. I think it was probably implied but not ever addressed under Oregon law. So I like ROLCA subsection 2 for that.
Yeah.
And then on 502A3, what it says is that the transferee does not necessarily get to participate in the management of the company's activities or have access to books and records. Subpart A, where it's talking about participating in management or the conduct of activities, is similar to ORS 63-249-3, where it says that the assignee can receive distributions when made, but doesn't get to participate in the management. So I think conceptually that is the same. I think where subparagraph B in ROLCA improves matters is that it starts to address some of the rights to information that a transferee may have, which is you don't necessarily, except as we deal with later, you don't necessarily get all the information that a member would get. And that's probably useful if you are dealing with someone who becomes a transferee who would actively, be a competitor or otherwise hostile to the ownership rights of the LLC itself. So I would say on 502A, I would recommend that we adopt ROLCA because it's essentially the same concepts as what we have, plus a little bit of improvement in how it's worded and put together.
Yeah, I think that's fine.
Comments, thoughts?
Okay. No, I have no problem with that. Anyone else?
Okay, so subparagraph B of 502, or paragraph B of 502, says a transferee has the right to receive distributions to which the transferor would otherwise be entitled. And this is similar to part of ORS 63-249-3. I think that the wording of this is carefully done and appropriately done, because what it does is it recognizes that the LLC can offset any amounts that that member owes prior to the transferee having the right to the distribution.
Yeah.
So if the member owes the LLC, $100 and transfers its interest, then what the LLC is obligated to pay to the transferee is only, if they would otherwise owe $1,000, they can offset that $100 that the prior, or that the member who transferred its interest owed, and then just distribute $900 to the transferee. And I think that's the appropriate way to do that.
The only thing that sort of pings the back of my head with this language, though, is that if you look at 63-249 sub 3, it talks about allocations, and this focuses on distributions. So you may have a tax cash discrepancy there, and I don't know if that's meaningful, right? Because the code is certainly going to step in and talk about what you can and can't do from an allocation perspective, but so I don't know, because when we talk about distributions, from what I hear, that I think we're talking about cash, right? Not necessarily tax.
Well, and that's a really good point, because one of the big problems in considerations in whether you would ever want to do a charging order or obtain a transfer of a member's interest versus whether you would want to try to execute on that interest back when we could do that, was whether you want to be stuck as a creditor with the tax consequences of a member that you don't necessarily understand.
Yeah.
I mean, that was always one of the big reasons that you wouldn't execute on an LLC membership interest, is because you could get stuck with all kinds of wacky tax consequences. You don't even know what they are.
Right.
And so I like the idea that ROLCA simply deals in distributions. It's dealing in cash. It's not trying to stick a transferee with tax allocations and leaving that to other law, because the transferee is not necessarily going to have any way of knowing what they're getting into.
Yeah. Roberta, do you have any thoughts on that?
Sorry, unmute. I read the ROLCA just to be talking about cash.
Yeah.
So
do we need to have it talk about non-cash?
I thought ROLCA elsewhere specifically got rid of this stuff about allocation of profits and losses. I thought that was I thought we had talked about that earlier in regard to a different section and agreed to ROLCA's dropping profits and loss.
I think we did, and I have this vague recollection that was something I was talking about.
Cody, I think you're
in the
correct.
400s.
I'm looking at page 91. I think it deals with that issue. I think ROLCA is just dealing with the cash side.
Yeah.
Yeah, especially in the comment at the bottom of 91 and top of 92, it talks about how they got rid of all that allocation of profit and loss stuff.
Yeah, I mean, I do think that I'm going to flag this because I think that's going to possibly freak out some of the tax lawyers in the room when we have this rolled out. But
well, who do you send the K1 to exactly?
Yeah. Right. And so that's, that is something that we're either going to have to address in operating agreements, or maybe, and maybe, Sandy, what we should do is reach out to, well, I mean, we have Victoria and Willie here too. So, I'd be curious to hear if either of you have any thoughts about that, or if this is something that we should table for now and then circle back to after we have a chance to, maybe talk with DOJ.
Yeah, I don't know if we can really, if there's a transfer, I don't know if we can separate out the allocation of profits and losses from the distributions. Though certainly ROLCA looks like they're talking just about the distribution, which is really what, if you have a transferee in bankruptcy, that's what they're concerned about, right? Or you have a creditor, they want to know money.
Or even if you just are transferring the right to receive distributions to a lender as part of an ordinary course transaction, you're providing your membership interest as security, and your distributions will then go to the bank to make your loan payments. I mean, you can do that. And so
and you'll still have the obligation to pay, to have the tax out.
Right. So the idea with ROLCA is it separates out the membership, the governance rights, and the ownership from the rights to receive money. And I would think the tax consequences, and I'm not a tax lawyer by any means, but I would think the tax consequences and liabilities stay with the member, and the cash goes where the cash goes. It just flows through wherever it gets assigned or transferred.
That's interesting. So you would have, are you saying conceptually you would have someone who is a member, remains a member, but you have a charging order against their economic cash rights?
Yeah. Or where they've transferred their economic cash rights voluntarily. It doesn't have to be involuntary.
Yeah.
You can promise to your best friend that any money that this LLC pays me, I will pay over to you, or I will have them pay directly to you. And you're still the member, and you still own it, and you still have your ownership rights, but what you
obligations.
Some piece of the cash flow.
Yeah, and the member would then still have the obligation to pay taxes on any profits that were allocated to them, because the tax consequences really are not the same as it would be treated, though, Valerie, I think as if for tax purposes, it would be treated as if the distribution went to the member and then went to whoever the member had transferred it to. Right.
So they get an outside basis adjustment.
Right, exactly.
So they don't have to pay tax on that.
Exactly.
And the transferee would have to pay tax because they wouldn't have that basis in the interest. They'd just be receiving the cash.
But that'd just be income.
Right. It'd just be income. Mm-hmm. I think that sounds appropriate.
Okay. My head exploded just a little bit, but that's okay.
Ooh,
It's
I have
partnership
accomplished something
tax.
for the
It's
day.
supposed to.
Okay, sorry.
Okay, that's all right. So I think that my recommendation on 502 section B is that we keep that as Rolka has proposed.
I'm fine with that. One thing I just wanted to note is that ORS says that the distributions, it's as and when made. I think that's implicit anyway, but I just thought I would flag the issue in case anyone thinks it ought to be explicit.
That's going to be a methods question anyhow, right?
I think when you say distributions to which the transferor would otherwise be entitled, you're not entitled to them until they are as and when made.
Right, and that is when you are entitled to them.
Right. So I
think it's sort of unnecessary language.
Well, I mean, that's true for cash basis taxpayers, right? But
Well, I think this is talking about, you get that right to distribution, at the time that it's decided that the company is making a distribution on date X. And when date X rolls around, you're entitled to that distribution, whether you're the member or the transferee. I just don't think, the ORS language as and when made is sort of very clear, but I just don't know. I think it's sort of unnecessary. And I agree with Teresa that we just adopt Rolka on this.
Any other thoughts on that? Let's move on to 502 section C. And this I could not find an Oregon statute analog for. This I think is new, but what it says is in the dissolution and winding up of an LLC, a transferee is entitled to an account of the transactions only from the date of dissolution. And so what this is saying, I think implicitly, is that a transferee is not necessarily entitled to information, but if the company's winding up, they're entitled to know that's what's happening and to understand what money they are and aren't going to get. Practically, I think that's useful because at that point you can say, okay, now I'm done. I've got the last distribution I'm ever going to get from this LLC. I can move on. So I like this. I don't see a reason not to do it, but I wanted to see what the group thought on this.
I like it too. And also the comments makes clear that what does it say? Okay, this is on page 124. The limited grant of information rights, blah, blah, blah. This subsection does not prevent a transferee from contracting with a member transferor to require the member transferor to disclose further information.
Yeah, and that's going to be pretty frequent if somebody is pledging their LLC membership distribution rights to a lender, because a lender will put in their agreement that the pledgor is required to provide them with all the information that they would get.
Mm-hmm.
So.
Makes sense to me.
Yeah, so you can bind your transferor, but you can't make the LLC give you information.
Right.
Yeah, which I like.
Yep, good.
So I suggest adopting C as written.
Okay.
Comments, disputes?
Not for me.
502D, I believe also is a new provision that we don't currently have. And it says a transferable interest may be evidenced by a certificate of the interest and
like
can
a
be
stock
transferred
certificate?
by a transfer of the certificate. I don't know that I've ever seen an LLC membership interest certificate before. I mean, does anybody even do those? I guess if they do, it makes sense to have this provision.
I on occasion have done that, where somebody actually wanted a certificate. It's very unusual, but I've done it.
You're like, you're not buying a corp? Let me explain to you the difference.
Exactly.
Well, if people do this, even rarely,
I'm fine
then I
with
think it makes sense to explain how you can document it consistently with what people are doing.
Yeah, and it's permissive language. It's non-mandatory, so I think that's fine.
Yeah, I don't see it changing the way business practitioners typically don't do a certificate. I agree with David. It's very rare. I've seen it on a handful of occasions. So.
Okay, then I with that, I would suggest that we adopt it. My only question was, is it unnecessary? But I guess it's probably useful in the, extremely rare cases where it comes up.
Yeah.
It'd be like constructive delivery of a gift. How do you give a LLC interest? In theory. Probably wouldn't have to do it that way though, but yeah.
You sign the piece of paper saying, I give you an LLC interest.
I hereby assign my interest in the LLC to you, or a pledge or a hypothecate.
Yeah, exactly. So, but if they want a pretty piece of expensive paper, that's cool too.
Okay, so moving on to 502 sub E. A limited liability company need not give effect to a transferee's rights until the company knows or has notice of the transfer. This is similar to ORS 63-249-6.
Yeah.
Reasonable notice of and proof of the assignment. Oregon law requires proof of the assignment. This requires notice or knows or has notice. I don't know how important it is that we require proof.
Unless we're going to require the certificate.
Yeah, I think this is better language.
Yeah, I like it too.
Okay.
Proof of assignment, I think, is on reflection is a little bit odd language.
Yeah, it seemed kind of archaic to me in the context. So I think we should just adopt ROLCA on this one, and I like the language in ROLCA. 502 subsection F is another one that I think is new. That's not in current Oregon law, or at least I couldn't find that it was. A transfer of a transferable interest in violation of a restriction on transfer is ineffective if the transferee has notice or knowledge of the restriction. So we get into the realm of bad actors, and you have a company, LLC, that has a restriction that says thou shalt not transfer your transferable rights. And the bad guy goes to an innocent person who doesn't know about that transfer restrictions and says, here, do you want to buy my transferable rights? And the person says yes and pays for it. You're protecting the bona fide third party who didn't know of that transfer restriction. And you're not protecting the bad guy who did know about it. Mm-hmm. That makes sense to me. I don't suspect that this comes up a whole lot. And I think there are a lot of situations where the transfer is going to be as an operation of law or involuntary, where it's not really, where the transfer restriction wouldn't work anyway. Mm-hmm. So for example, if you had a provision in an LLC operating agreement that says thou shalt never transfer your transferable interest in this LLC, and the member files bankruptcy, it's transferring to the bankruptcy trustee whether the LLC agreement says that or not.
Right.
I think what this would do is clarify that under circumstances like that, the transferee is going to actually get the right to the distributions, which is what they should be getting. So to me, this cleans up some stuff. It sort of makes it clear who can take advantage of well, let me say that a different way. I think what it does is it says, if you're a person who knows there's a transfer restriction and you take the transfer anyway, you don't get it. But otherwise, innocent third parties and people who get transfers by operational law, they get the transfer. And that makes sense to me.
And I think the comment on page 125 towards the top that says the term notice includes reason to know, section 103B1, and ordinarily a potential transferee has reason to inquire about transfer restrictions that might be contained in the operating agreement. And so I think that's clear that the language intends sort of some amount of inquiry notice is imputed upon the transferee.
Yeah. I think that's how I read that as well,
Yeah.
and it makes sense. So
I would recommend adopting it.
Yeah, I recommend adopting 502F.
Okay.
Section 502G is most analogous to ORS 63-249-5. If a member transfers a transferable interest, the transferor retains the right of the member other than the interest transferred and retains all duties and obligations of a member. This is really the concept that we were talking about, that what you can transfer is your right to receive distributions, but you're still a member, you still have all your duties that you would otherwise have as a member. You're still stuck as a member unless and until you get dissociated, which is governed under other sections.
Mm-hmm.
And that seemed to me consistent with 63-249-5. The ORS section makes clear that you're not released as a liability from any liabilities specifically. I think that's the same as retains all duties and obligations of a member for all practical purposes. So I would go with the roll call language because I don't think it is a change in Oregon law.
Do you think, though, that there's a distinction, because what the ORS language says, you're released from liabilities as a member accruing or arising prior to your assignment, solely as a result of that assignment? I mean, is there any sort of ongoing obligation that a member, a non-dissociated member who'd assigned their rights would have?
You know, there may be if what you did was a partial assignment of your rights.
Yeah.
So if you assigned, let's say that you had an LLC and it like clockwork paid out $5,000 a month, and you assigned half of that stream of payments to your bank, you would still have the rights, obligations of a member. It would just, I mean, because you're still getting some income and you still have some responsibilities. I would not limit that to prior to the assignment, because I mean, the Oregon law is almost written like you have an absolute assignment of all or nothing. And in the real world, I don't think it works that way.
Okay.
Can you remind me what part of ROLCA talks about assignment of like the management rights and all of that? Is that a section we've already gone over?
So you can't transfer governance rights. You can, as I remember this, you can't transfer a governance right. What you can do is the LLC can disassociate a member who has transferred all of their economic rights under sections we haven't gotten to yet. And you can have provisions in your operating agreement that says if somebody transfers their distribution rights contrary to the default rule, the voting will change in the following ways depending on who attains those rights, whether it's an existing member already or whether it's an outside person who attains those rights. Mm-hmm. But I don't think this section really deals with that. I think it's dealt with in terms of how ROLCA deals with governance rights in other places.
Okay.
Section 6 talks about disassociation and when you can do that and what happens when a member is disassociated. And I think we get to that when we get to section 6.
Mm-hmm.
Okay.
Thanks.
Yeah, I think we can move on. I will probably mull this over a little bit. But
What is the concern that you have?
But no, I just thinking about, you know, when we're educating the bar about this, right? Like what sort of scenarios do we need to put together so that they understand, you know, this is not a sea change, but it's more of a clarification in where we're going with this. So
I think the way to frame that is that this really is part of the preservation of you get to pick your partner.
Yeah.
Which is if, you know, 3 people go into business as an LLC and it's, you know, Frank, Susan, and Eddie, and they always expect that it's going to be Frank, Susan, and Eddie. When Frank pledges half of his distribution rights to, you know, Marcus, the business is still Frank, Susan, and Eddie. It's still going to be Frank, Susan, and Eddie. It's what people expected all along, unless and until they decide to get rid of Frank for having done that.
Right.
Or they decide to invite Marcus in because he's now someone they like and want to bring in, and then they'll do that as part of, you know, rejiggering how their management works.
Mm-hmm. Mm-hmm.
But I think the idea is that you separate the transfer of the economic rights from what's going on with governance so that you can deal with one and not the other more clearly.
Mm-hmm.
Because right now, it's not often clear that they don't go together. So you have this whole line of cases where bankruptcy trustees end up with the rights to LLC memberships because the debtor who owns an LLC membership interest files a bankruptcy. And then the question is, what can the trustee do with that company?
Right.
Do they just get money? Do they get to participate? Can they get information? Can they force a distribution? Can they force a liquidation? Can they force the company to stop doing business? This clearly separates those two things. And I think that's
and I think maybe even beyond the bar, I think the education is going to need to happen with the CPAs. You know, how do you account for that, and how do you prepare that return? Sandy, can you flag this, and we'll run this by Brigetta and see if she's got any additional thoughts on, you know, how do we educate people on this?
Sure.
Okay.
Okay. So my recommendation is we adopt 502G.
Okay.
Any dissent on that? Anybody want to comment? Okay. And then the last of section 502 is 502H. If a member transfers a transferable interest to a person that becomes a member, then the transferee is liable for the member's obligations and that are known to that transferee when the transferee becomes a member. This is somewhat analogous to what's in ORS 63-249-4, which says until you become a member, you don't have any obligations as a member solely because you received the assignment. And I think what H is really getting at is you can be a mere transferee of the economic rights. And if you're a mere transferee of the economic rights, you don't have any obligations to anybody other than to sit there and hold your hands out and wait for money to fall into them. But if you decide, and the company decides, that you're actually going to become a member, then starting on the day you become a member, you're a real member and you have all the liabilities and obligations you'd have as a real member.
Right.
That makes a lot of sense to me that we ought to draw those lines that way. I think it's a little bit clearer probably than what's in 63-249-4 in the ORS.
That makes sense to me too, but I'm slightly concerned about the last clause, known to the transferee. Now, presumably the transferee should do due diligence and figure out what the obligations are, but I don't know, are we concerned about protecting a transferee who has, you know, the transferor is not disclosing obligations?
Well, and I think that's the comment that Michael made, which is, you know, notice includes reason to know. If it's known to the transferee, I mean, if you need to know what you're getting into if you're actually going to become a real member.
Sure.
Yeah.
As opposed to just a transferee. It's one thing to just say, I want cash coming my way. It's another thing to say, I want to be a real member and have rights to participate and the situations that, and the reason I think it has this clarification of known to the transferee is because there are situations where, you know, there's some you really want another LLC member to join because you want somebody else to be liable along with people who are already there. And so you sucker somebody into becoming a member by not telling them about all the obligations they're going to have. And,
well, and it's
in some ways, this strikes me as a way of.
Yeah, it specifically refers to 403, which is the obligation to make contributions, and 406, which is, you know, liability for improper distributions. And I think with the improper distributions, I think that the knowledge aspect is important, right?
Yeah, and I agree with that. And I guess I'm just, is this referring to as soon as a member becomes a member, then the transferee becomes a member, then that transferee is subject to obligations? Or does it mean that the transferee is subject to the obligations of the transferor that the transferor has not done?
Yes, but for 403 and 406. Right? Yeah. Because they've agreed to make those contributions and they've accepted the improper distributions. So that makes sense to me, that, you know, you have someone who's been proceeding merrily as a member and does these things, right? And they're maybe specific to them. And so then, you know, you can't just get out of it by saying, oh, now it's your problem.
And I think generally the transferee could not be a member without their consent, could not be a member involuntarily.
Right.
Oh, yeah.
Right. So basically, what you know you're on the hook for, you're going to be on the hook for.
Yeah, that makes sense.
And it does say known, and other places in this section, it references to have notice, which is that sort of duty of inquiry. And so I read that as actual knowledge in the transferee. So, you know, I guess if with those perspectives, I don't have a problem with H.
Yeah, that was interesting. There's no comment to ROLCA.
It is interesting.
Yeah,
it is interesting.
You know, because it doesn't seem to me to be totally clear on its face, but there were no comments.
Well, I mean, what it does is I think it encourages an LLC that knows it has a current member with outstanding obligations and somebody who wants to take over that member's position and become the new member. It encourages them to say, hey, we'll let you become a new member, but you should know that this former member that you're going to take over for, they owe us $10,000.
Yeah.
And I think encouraging that kind of transparency is a good thing, because you want people to know what they're going to get into.
Yep.
So I recommend that we adopt H as well.
I agree.
And Valerie, give you a time check real quick. We're at 2 minutes till noon.
Yeah, that's why I was thinking maybe we should stop here and then start up with 503 when we come back next month. Sandy, I don't have a calendar thing.
Yeah, I need to do the calendar invite. We scheduled for the 10th of September. I'll actually get that calendar invite out today. Did you want to do October, or do you want to wait on that?
No, I want to do October too, because I like to have us two out.
Okay, so September 10th, and I'll get that calendar invite out, and then October.
Okay.
Let's take a look.
So anybody have any strong preferences?
I can't do Monday or Wednesdays once school starts.
Teaching Mondays and Wednesdays?
Yeah.
Do you know what Mosin's schedule's like? I assume he'll probably be back with us when the school year starts up, maybe, hopefully.
He alluded to that.
I can look. It might take a moment for me to find it, but I can look.
I have a standing meeting on Thursday morning every week in a nationwide big case that I can't really move. So
Sure. Well, that makes sense. Yeah. Do we want to set this one for a Friday? What do people look like on Friday? Okay.
Do like a Tuesday. It sounds like Tuesdays are not so bad.
Tuesday or Friday, and I don't have a preference. I mean,
generally it's easier to get people on Tuesdays than Fridays.
Sure. What about the 6th of October?
Sure.
That
Works for me.
Yeah, that's fine. Sorry, I'm not finding Mosen's schedule because
No,
he's
that's
in Portland
fine.
and I don't save the Portland schedule.
Sandy, would you mind checking with him though?
I will.
It's been a while since he was able to join us, and it would be nice to have him back.
Yep. So I'll get those. I'll get the September 10th and October 6th calendar invites out
Okay.
as soon as I can.
Great.
So next time I will be able to finish up charging orders next time.
Okay.
In section 504, we've already done half of. So
Unless we're adding stuff to 504, I mean that's always an option too.
So just prepping for. Oh, I'm sorry, Teresa.
I was going to say, I think we would be moving on to whoever's doing Article 6 then next.
Is it really that short?
Yeah.
So who's on Article 6?
Goodness.
Anybody gonna claim?
Oh no, that's me.
Oh, it's Valerie.
Oh no, that's me and David.
Oh my God. Good work.
All right.
All right.
It seemed so long ago, so far away when we agreed to this. Okay.
Yeah,
right.
and I think that we'll be able to cover charging orders probably in an hour or less. So if that
Oh my
helps.
God, we're gonna have to do real work then.
And,
Opposed to just convincing on everybody else's hard work. All right, sounds good. So we'll plan on that. Well, at least it looks like Article 6 is also very short. We probably won't get to Article 7 next week, which is dissolution. And then after that, I have Cody and Kyle on action by members for Article 8. But I doubt we'll get anywhere near there for the next couple months. So
no.
Maybe on Article 8 as well, although I think you guys picked when I wasn't at a meeting.
Oh.
So let me know.
That's what happens.
Yeah, that was like a year and a half ago. No,
yeah, well, Cody, Kyle, and Aurelia, then we'll put you on Article 8.
though I wouldn't expect that until November, likely.
Probably, yeah.
Okay.
Thanks, Teresa. Thanks,
Yes,
Cody.
Thank you,
guys.
Teresa.
And thank you again,
thank you,
Cody. You had
And,
two
thanks, guys.
terrible sections, and so I appreciate you leading those.
And Cody, if you just send me over your notes on 410, I'll start working on a red line copy.
Okay, sounds good.
Perfect.
Great, thank you
Okay,
all. I
bye,
really
everybody.
appreciate all of your time and hard work on this. I feel like we're making great progress, so thank you.
No, this is a good meeting. Thank you, everybody.
Bye.
Thanks, everyone.
Bye.
Thanks,
Bye.
guys.
Thank you. Thanks a lot. Bye-bye.
Thank you.